Elon Musk stood confidently at the steps of the Supreme Court, a slim folder tucked under his arm containing documents nobody knew existed. Just hours earlier, Chief Justice John Roberts had signed an unprecedented order threatening Musk with contempt of court and possible jail time for his refusal to comply with a secret gag order. The Chief Justice, with 18 years leading America's highest court, believed he'd finally cornered the outspoken billionaire who had been criticizing the judicial system for months. But as cameras flashed and reporters crowded around, Musk's slight smile suggested something nobody expected. He wasn't there to apologize or back down. He was there to expose what he called the biggest judicial overreach in American history. What happened in the next few minutes would leave Roberts completely blindsided and might forever change how Americans view the Supreme Court. The Supreme Court building loomed in the background, its marble columns standing as symbols of American justice as reporters gathered for what they expected would be a standard press conference. Network cameras went live as Elon Musk, wearing his trademark black t-shirt under a dark blazer, approached the microphones. For months, tension had been building between Musk and the judicial establishment. It started when Musk began posting documents on X showing what he claimed were patterns of politically motivated rulings across federal courts. His campaign gained traction when he created a judicial transparency project, using AI to analyze thousands of decisions, highlighting what he called statistical anomalies in how certain judges ruled on politically sensitive cases. Chief Justice Roberts, known for his measured temperament and institutional protectiveness, had initially ignored Musk's provocations. With his distinguished career spanning Republican and Democratic administrations, Roberts had navigated contentious issues while maintaining the court's reputation. But when Musk's project began naming specific justices, including Roberts himself, Chief Justice responded with a rare public statement defending the judiciary's integrity and warning against dangerous attacks on democratic institutions. Behind closed doors, Roberts had convened a special judicial panel that issued a sealed order demanding Musk remove specific posts and halt his transparency project pending review. When Musk refused, posting, "I will not be silenced by those hiding." Behind black robes, Roberts signed the contempt order that now threatened America's richest man with actual jail time. The stakes couldn't be higher. For Roberts, this was about preserving judicial independence and the court's legitimacy. For Musk, it was about exposing what he called the unaccountable power of unelected judges and defending free speech. And for millions of Americans watching, it represented a fundamental clash between established institutional power and a tech-empowered challenge to that authority. Musk approached the microphones, the crowd hushing as he placed his folder on the podium. He began calmly, "I'm here today because the Chief Justice of the United States has decided that American citizens no longer have the right to question their government." News cameras zoomed in as Musk continued, "Yesterday I received a sealed order threatening me with jail time if I continue to share publicly available court records and statistical analysis showing patterns that some powerful people don't want you to see." As he spoke, Supreme Court police officers moved closer to the edge of the crowd. A Justice Department official was seen on his phone, speaking urgently. Tension grew palpable. "What I'm about to share with you wasn't part of my plan," Musk said, opening the folder. "But when you threaten a citizen with imprisonment for asking questions, you've crossed a line that cannot stand in America." The crowd pressed forward as Musk held up the first document. "This is an email sent 2 months ago from Chief Justice Roberts' private account to a law clerk. In it, he specifically discusses ways to, and I quote, address the Musk problem before his influence further erodes confidence in the judiciary." Gasps rippled through the gathered journalists. A CNN reporter shouted, "How did you obtain private emails from the Chief Justice?" Musk's expression hardened. "I didn't hack anything, if that's what you're suggesting. These were provided to me by whistleblowers inside the judicial system who are gravely concerned about what they're witnessing. He held up a second document. This is a meeting transcript from a closed-door session where Roberts discussed with several circuit court judges the possibility of coordinating responses to what he called external threats to judicial autonomy. My name appears 17 times in this transcript. The crowd erupted with questions, cameras flashing rapidly. A Fox News reporter pushed forward. Are you suggesting the Chief Justice was organizing a coordinated legal response targeting you? Specifically? I'm not suggesting anything, Musk replied. I'm showing you their own words. As the commotion grew, a Supreme Court spokesperson approached the edge of the gathering, attempting to get reporters' attention, but few noticed as Musk continued his methodical presentation. Most concerning is this third document, Musk said, holding up several pages of what appeared to be text messages. These show communications between Justice Roberts and two members of Congress discussing the potential legislative remedies to deal with social media platforms that allow judicial criticism that crosses the line. The Supreme Court spokesperson finally reached a microphone at the periphery. This is completely inappropriate. Mr. Musk has no authority to discuss purported private communications, and these claims are categorically denied. Musk nodded toward the spokesperson. Denial noted. But Americans deserve transparency from those who hold power over them. The situation intensified when Musk's lawyer stepped forward with a laptop. We're prepared to share more, including audio recordings of conversations that will remove any doubt about the authenticity of these documents. Within minutes, Musk of Roberts was trending nationwide. Conservative commentators were calling it the biggest judicial scandal in American history, while liberal analysts questioned the legality of Musk's disclosure of private communications. The Supreme Court's Public Information Office released an urgent statement calling Musk's claims distortions and fabrications designed to undermine a fundamental American institution. But the momentum was clearly shifting as more journalists began reviewing the documents Musk had provided to select outlets. A respected legal reporter from the Washington Post tweeted, I've reviewed the Roberts emails. If authenticated, they represent an extraordinary breach of judicial norms. 2 hours into what had become an impromptu battlefield on the Supreme Court steps, Musk revealed what he called the smoking gun. He nodded to his legal team, who distributed copies of a document to key reporters. What you're receiving, Musk announced, his voice carrying across the now silent crowd, is a draft of an unpublished internal court memo written by Justice Roberts himself, dated just 3 weeks ago. In it, he outlines what he calls a multi-pronged strategy to contain technology sector influence on public perception of the judiciary. Musk paused, letting the reporters scan the document. I want to draw your attention to paragraph 3, where the Chief Justice specifically writes that Musk represents an unprecedented challenge requiring unprecedented measures, including potential use of the court's contempt powers. The memo, displayed on large screens that Musk's team had set up, showed Roberts' signature and official Supreme Court letterhead. Its authenticity was difficult to dispute. This proves what I've been saying all along, Musk continued, his voice growing more forceful. The contempt order against me wasn't about protecting the integrity of any specific case or judicial proceeding. It was about silencing criticism of the institution itself, criticism based on data and public records that anyone can verify. The Supreme Court spokesperson, who had been trying to manage the situation, was now on the phone, looking increasingly distressed. Reporters noticed a group of dark-suited individuals who appeared to be senior court officials huddled near the building entrance. A reporter from the New York Times raised her hand. Mr. Musk, how can you be certain these documents are authentic? The Supreme Court operates under strict confidentiality protocols. Musk nodded, as if he'd anticipated the question. An excellent point, which is why we've had 3 independent forensic document experts verify their authenticity. He gestured to his legal team, who distributed another set of papers. These are their signed affidavits, confirming the document's authenticity based on paper composition, signature pressure analysis, and digital metadata from the electronic versions. CNN's legal correspondent pushed forward. Even if authentic, isn't it possible these are simply drafts that were never officially adopted as court policy? Another good question, Musk replied, seemingly unruffled. Which brings me to this. He held up his phone, showing what appeared to be a calendar invitation. This is a scheduled meeting from 2 weeks ago, with Chief Justice Roberts and 7 federal judges, with the agenda item, Implementation of Judicial Protection Measures. 3 days after this meeting, I received the sealed contempt order. The crowd murmured as Musk continued methodically building his case. Behind him, his team displayed a timeline on the large screens, showing a correlation between his posts about judicial transparency and subsequent actions taken by the court. But here's what Chief Justice Roberts didn't anticipate, Musk said, reaching the climax of his presentation. He motioned to his chief counsel, who stepped forward with another document. This, Musk said, holding up the paper, is a formal opinion written by former Supreme Court Justice Samuel Alito in 2019, never published but circulated internally, specifically addressing the constitutional limits of the court's contempt powers when it comes to public criticism. Musk began reading. The power to punish for contempt is among the most severe powers entrusted to the judiciary and must be limited to actual interference with the administration of justice. It cannot be weaponized against those who merely criticize, question, or scrutinize judicial decisions, no matter how uncomfortable that scrutiny might be. Looking up from the document, Musk delivered his knockout punch. Justice Roberts voted to endorse this opinion. His signature is right here, dated February 2019. He agreed that what he's now trying to do to me is unconstitutional. The crowd erupted. Journalists frantically filed updates. The Supreme Court spokesperson had disappeared entirely. On social media, legal experts were already weighing in, most concluding that if authentic, the document showed a troubling pattern. A Washington Post reporter called out, "If what you're saying is true, why would Justice Roberts take such a risk knowing these documents existed?" Musk's expression turned thoughtful. "I believe he never expected these documents to see the light of day. The Supreme Court operates with more secrecy than almost any other institution in our democracy. No cameras in the courtroom, deliberations, completely private, internal memos sealed for decades. That level of opacity might have made sense in the 18th century. But in the digital age, it's becoming unsustainable." Musk walked to the edge of the platform, his voice taking on a more intimate tone despite the size of the growing crowd. "I want to be clear about something. This isn't about attacking the judiciary as an institution. We need independent courts. But independence doesn't mean immunity from scrutiny." He pointed to the court building behind him. "Inside those walls are good people, justices and staff who believe in the rule of law. But somewhere along the way, institutional self-protection began taking precedence over transparency. And when that happens in any institution, corrections are necessary." A reporter from Newsmax shouted over the din, "Mr. Musk, are you saying the Chief Justice is violating the Constitution?" Musk's response was measured but devastating. "I'm saying Justice Roberts is violating his own stated principles when they became inconvenient. He's using the power of his office not to uphold justice, but to shield the judiciary from legitimate public oversight. And that should concern every American, regardless of political affiliation." The crowd fell silent as Musk continued. "Let me show you something else." His team projected a data visualization on the screen. A complex network analysis showing correlations between judicial rulings and political affiliations. "This is what my team has been working on," using AI to analyze patterns in judicial decisions across federal courts. We're finding statistical anomalies that suggest factors beyond the law may be influencing outcomes. This isn't about individual cases, but patterns that emerge when you analyze thousands of decisions. He paused, letting the implications sink in. This is the real reason for the contempt order. Not because I violated any specific court rule, but because this kind of transparency threatens institutional comfort. A legal analyst from ABC asked, "Couldn't this kind of analysis undermine public confidence in the courts?" Musk shook his head firmly. Sunshine doesn't create problems, it reveals them. If the data shows our courts are functioning impartially, that strengthens public confidence. If it reveals problems, we can address them. Either way, democracy benefits from transparency. As if to underscore Musk's victory, at that moment, a clerk emerged from the Supreme Court building and handed a note to Musk's attorney. The attorney read it quickly and passed it to Musk, who scanned it before looking up with a slight smile. "Ladies and gentlemen," Musk announced, "I've just been informed that the contempt order against me has been temporarily stayed pending further review. It seems the Chief Justice may be reconsidering his position." The crowd erupted again, cameras flashing as Musk stood on the steps of America's highest court, having apparently forced one of the nation's most powerful figures to back down. "Let me be absolutely clear about what just happened," Musk said, his voice carrying over the commotion. "The highest legal authority in America just blinked, not because I have more power, I don't, but because in a democracy, truth backed by evidence will eventually prevail over even the most entrenched authority. It wasn't just a personal victory, it was a moment that challenged the relationship between technology, transparency, and traditional, institutional power." As Musk stood there, the setting sun cast long shadows across the court steps, symbolically marking a potential turning point in the balance of power in American democracy. The fallout was immediate and far-reaching. Within hours, like Supreme Accountability and Musk vs. Roberts were dominating social media platforms, generating over 2 million posts in the first 24 hours. Cable news networks switched to continuous coverage, legal experts debating the constitutional implications while political commentators analyzed the power dynamics at play. By evening, a visibly strained Roberts issued a terse statement announcing that the contempt order had been vacated entirely and that the Supreme Court would be reviewing its internal procedures regarding transparency and public engagement. The statement notably lacked any denial of the documents Musk had revealed, an omission that spoke volumes. Behind the scenes, sources reported chaos within the Supreme Court's administrative offices. Emergency meetings were convened among the justices, with rumors of heated disagreements about how to respond. Justice Sonia Sotomayor reportedly argued for a more transparent approach, suggesting the court should get ahead of this story rather than chase it. Justice Clarence Thomas allegedly favored a more aggressive pushback, questioning the authenticity of Musk's evidence. At the White House, Press Secretary Anna Martinez faced relentless questions about the administration's position. "The president believes in both judicial independence and the fundamental right of citizens to question their government," she stated carefully. "He is monitoring the situation, but considers this primarily a matter between the judiciary and private citizens." When pressed further about whether the president supported Musk's actions, Martinez walked a careful line. "The president supports transparency in all branches of government, while recognizing that certain deliberative processes benefit from confidentiality. He believes this situation offers an opportunity to recalibrate where that balance should lie." Congress, however, was less restrained. Senator James Howard, chair of the Judiciary Committee, announced immediate hearings on potential abuses of contempt power and the need for greater judicial transparency. In a fiery press conference, he declared, "No American should face jail time for questioning those who hold power in our democracy, especially unelected power." Representatives from both parties scrambled to position themselves. Conservative members praised Musk's courage in standing up to judicial overreach, while progressive representatives expressed concerns about billionaire influence, while still acknowledging the need for greater judicial transparency. Representative Lisa Chen captured the bipartisan moment when she tweeted, "No institution, not even the Supreme Court, is above scrutiny in a democracy." By nightfall, the story had expanded beyond American borders. International legal observers weighed in, with the European Court of Human Rights issuing a statement reaffirming that judicial independence must be balanced with appropriate transparency measures. The British Supreme Court announced it would accelerate its own planned review of transparency protocols. Legal scholars from across the political spectrum offered varied analyses. Harvard law professor Elena Markson observed, "What we're witnessing is a collision between traditional institutional authority and technology-enabled transparency. Regardless of where one stands on Musk himself, his ability to challenge the court's authority represents a significant shift in power dynamics." Yale constitutional scholar James Hernandez pointed out historical parallels. This is reminiscent of the Pentagon Papers case, but with a crucial difference. Today's technology allows for immediate global dissemination of information that institutions might prefer to keep private. The court is facing the reality that in the digital age, institutional secrecy is increasingly difficult to maintain. Conservative legal analyst Michael Patterson was more direct. "Roberts overplayed his hand and got caught. This may be the most significant challenge to the court's moral authority since Bush versus Gore." The Chief Justice forgot that while the court interprets the Constitution, it doesn't stand above it. By morning, public opinion polls showed Americans divided along familiar partisan lines about Musk personally, but united in support of greater judicial transparency. A Gallup flash poll revealed 78% of Americans believe the Supreme Court should be more transparent about its internal processes, with only 8% supporting the use of contempt powers against critics. For Musk, the victory extended beyond the immediate legal battle. His judicial transparency project, which had been the source of the conflict, saw its user base triple overnight. The project's website crashed repeatedly as millions attempted to access the AI tools that analyzed judicial decisions. Tech stocks rose on what analysts called the Musk effect, with markets apparently relieved that a potential jailing of America's most prominent entrepreneur had been averted. Musk himself remained strategically visible but legally cautious. In a lengthy post on X, he wrote, "Today wasn't about me versus Roberts. It was about whether powerful institutions can silence questions they don't like. America's founders created a system of checks and balances, but the ultimate check on power has always been an informed public." The post was accompanied by an announcement that his judicial transparency project was expanding to include a legal defense fund for journalists and researchers facing legal pressure for reporting on court activities. "The Fourth Estate must be protected," Musk wrote, "especially when it examines powerful institutions." This announcement prompted an immediate surge in donations, with the fund reaching $50 million within hours. Law schools across the country reported increased interest in courses related to judicial ethics and transparency, with several announcing new research initiatives focused on court accountability. The media landscape fractured along predictable lines. Fox News ran continuous coverage under the banner "Musk exposes judicial overreach," while MSNBC featured panels discussing the dangers of billionaire oversight. More nuanced analysis came from legal publications, with the American Bar Association Journal publishing an emergency special issue on transparency, technology, and the courts. Politicians from across the spectrum sought to align themselves with aspects of the story that resonated with their bases. Former President Trump weighed in, calling Musk a warrior for free speech, while criticizing Roberts as part of the deep state. Progressive Senator Elizabeth Warren acknowledged the need for judicial transparency while warning against allowing billionaires to set the rules of our democracy. Silicon Valley responded with a wave of new transparency tech announcements. 3 major tech companies unveiled plans for AI tools similar to Musk's judicial transparency project, but focused on different institutions: Congress, administrative agencies, and state courts. Venture capital firms announced a new focus on accountability tech as an investment category. Civil society organizations mobilized rapidly. The ACLU announced a new judicial transparency initiative, while the Federalist Society held an emergency symposium on the proper limits of judicial secrecy. The Knight Foundation committed $100 million to journalism projects focused on institutional accountability across all 3 branches of government. Legal experts suggested the confrontation would have lasting implications far beyond this single case. The Supreme Court has traditionally operated with significant opacity, noted constitutional scholar Rebecca Wellington. Musk has effectively forced a conversation about whether that opacity remains appropriate in the digital age. This may be remembered as a turning point in the court's relationship with the public. By the following week, Chief Justice Roberts had announced the formation of a commission to review the court's public communication practices and transparency measures. The commission would include judges, legal scholars, journalists, and technologists, a level of outside involvement unprecedented in the court's history. 2 other justices issued a joint statement supporting reasonable measures to enhance public understanding of the court's work while preserving judicial independence. Justice Elena Kagan gave a previously scheduled speech at Georgetown Law School, where she acknowledged that institutions must evolve to maintain public trust in changing times. State Supreme Courts began announcing their own transparency initiatives. The California Supreme Court committed to live streaming all oral arguments, while the Texas Supreme Court announced a new public database of judicial recusals and potential conflicts of interest. Legal observers noted that the ripple effects were spreading through the entire judicial system. In newsrooms and university classrooms, on social media, and at dinner tables across America, people debated the fundamental questions the confrontation had raised. How much transparency should we expect from our courts? Does more public scrutiny strengthen or weaken judicial independence? Can technology tools provide meaningful oversight of complex institutions? The confrontation revealed deeper tensions in American society about institutional power in an age of democratized information. Musk, representing technological disruption and information freedom, had effectively challenged one of America's most established institutions and appeared to have won the first battle. But sophisticated observers recognized that this was merely the opening chapter in a longer story about the evolution of institutional accountability. As the story continued to unfold, one thing became clear. The relationship between America's traditional centers of power and its technology-empowered citizens was being fundamentally renegotiated. And while this particular confrontation may have reached its climax, the larger struggle over transparency, accountability, and the proper limits of institutional authority was just beginning. What we're witnessing, wrote Pulitzer Prize-winning journalist Maria Sandoval, is nothing less than a recalibration of power for the digital age. When institutions designed in the 18th century meet 21st century technology, the resulting friction creates heat, but also, potentially, light. Thanks for watching this detailed breakdown of the historic confrontation between Elon Musk and Chief Justice Roberts. If you found this analysis valuable, please hit the like button and subscribe to our channel for more in-depth coverage of the evolving relationship between technology, power, and American institutions. Leave your thoughts in the comments below. Do you think Musk was right to challenge the Supreme Court this way? We'll be following this story as it continues to develop.